She moved in January, paid a couple months and then stopped paying. Why didn't you just move out? This seems like such a deplorable place to be. You're living in this place with improper sewage and you've had no heat and there are issues regarding that.
She was my girlfriend. We've been together almost 8, 9 years. So common law, we're basically married, but she's with another man now. So
they're substantially behind, $10,000 behind in rent. He's not allowed to be there anyway. Now, do you understand if you're not out by that date, you'd be subject to being evicted, where the sheriff can come and physically put you and your stuff out? You understand that? Or you can get your income tax refund, or you can sell a car or win the lottery. Either way, you got to pay the rent or move by June 30th.
I've heard my father is going to help me pay it. I'm going to get a job. You know,
It's been 6 months.
we can't pay bills.
The title of the case is Quail Run Apartments LLC versus Cody Duckworth and Araya Alexander. They're both here by Zoom. The esteemed Mr. John Bradshaw is here live in person. The manager, Paul Davidson of Quail Run, is here. And Meg Bauer is here from Legal Aid. We were here last week on June 13th, and we determined at that time the rent in arrears was $3,000. They'd been working with their case manager at Keystone. I don't think Miss Bauer was here last week, but they did contact Legal Aid.
I was, Judge.
Were you?
Yeah.
I didn't give you credit.
That's okay. I was in consult during their, a large part of their hearing.
Well, maybe that's it. All right. At any rate, Mr. Bradshaw has provided me a consent order for conditional dismissal. Defendant agrees to vacate the unit by July 20th. That's 30 days from now. Plaintiff agrees to waive any amounts of rent which may be due pursuant to this tenancy, either due now or as of July 20th. The security deposit shall be handled as provided by statute, meaning you need to give your forwarding address in writing within 3 days, 4 days of your moving, and turn in the keys, and then they can apply the security deposit to unpaid rent or other damages, or they have to return it to you. Mr. Duckworth and Miss Alexander, did you agree to those terms and conditions?
Yes, sir.
And if I may, Your Honor.
Just a minute, Mr. Duckworth, do you agree as well?
Of course.
All right. Elaine, could you print that email from Meg, and I'll have a signed copy on behalf of her. Mr. Bradshaw, on behalf of Quail Run, is that your agreement?
Yes, I just would, I want to make sure that we're not missing anything. That's a CD that I prepared. Meg, did you send another document?
I did, John. It's, you know, that format that I use that walks it out in more plain English. And I format it that way so they can present it to future landlords in a way that makes sense. But because you haven't reviewed it, we should stick with the document that you used. I believe it covers the same.
Well, all right. Elaine's going to print it and bring it into us.
Yeah. I just want to make sure on mine, it's clear that we're waiving any and all amounts that might be due for rent.
Which is quite a unusual condition. And so that is important.
Judge,
Yes?
my name is Trish Brown. I'm the owner of the property management company. So I'm here with Paul today. And it is very unusual that we would say, hey, no, we're just going to waive your money. Because we typically don't really want to do that. The owners of the properties are losing out in a big way. And it'll take probably 2 or 3 more months to get the apartment ready to move someone else back in. So we're actually losing, 7 months worth of rent for this owner. But I will agree, if they're out by the 20th, we'll waive that $3,000.
All right, very good. Thank you. Now, do you understand if you're not out by that date, you'd be subject to being evicted, where the sheriff can come and physically put you and your stuff out. You understand that?
Yes, sir.
Yes, we do.
All right,
We already got most of our stuff, pretty much everything packed and ready to go. So,
very good. All right, I'm waiting for that order to come. I'm told that sometimes the clerks can't hear me, but hopefully she got that message.
And I apologize for this, Judge. I was not in the office yesterday.
That's all right. Sometimes things happen. We are a little time crunched here, but I'm not sure. Anyway, I think hopefully Elaine is printing that. Meg, I didn't put you down as president any of these. You must have been in a long consultation when we were doing Casey's stuff.
I had a couple of back-to-back consultations, yeah.
Laura, could you check on that? Get me a copy of that conditional order of dismissal. I'm not sure what's going on.
The good news, Judge, I think Attorney Bradshaw and I got another one of your cases to settlement.
Yeah, he had advised the 10-940 case is settled. He's stuck here for a while, so he's gonna experience greater metropolitan Centerville for a little bit between his cases. All right, thank you.
You're welcome.
All right, this is a more clean copy of this. It's entitled, oh, wait a minute. Elaine? I only got one copy. Laura, could you help me again? It is hereby ordered the case is dismissed on these conditions. I need a copy for Mr. Bradshaw also. So make me one extra copy.
Thank you.
Anyway, we'll get to it. The parties agree that Mr. Cody Duckworth and Araya Alexander and their minor children shall remain in possession of the property or may remain in possession of the property through July 20th and not beyond. The parties agree that Mr. Duckworth and Ms. Alexander shall have through July 2025 to vacate the premises and return the keys to Quail Run Apartments or its agent. The parties agree that any personal property remaining on site after defendants return the keys shall be considered abandoned and may be removed without liability and does not provide grounds for default. The parties agree that the plaintiffs and agents will waive any amounts of rent and other fees under the tenancy which may be due now or would ordinarily accrue through July 20th, 25th. And Ms. Brown has confirmed that. The parties agree that the security deposit is not contemplated by this agreement and will be handled as provided for by statute after tenants vacate. The parties agree that plaintiff eviction lawsuit shall be dismissed in accordance with the Court Rule 2.602C, and it shall remain dismissed unless defendants do not follow the agreement. The parties agree that Mr. Duckworth and Ms. Alexander and their children, if they do not vacate the premises on or before July 20th, the plaintiff may ask the court after July 21st to immediately reopen the case and ask the court to enter a judgment without a trial or hearing and may ask the court to immediately issue a writ of eviction. The parties agree that if the plaintiff asks the court to reopen the case and the court is satisfied that the defendants have broken the agreement, the court must reinstate the case and must immediately enter a judgment against the defendants. The court must also enter the writ of eviction and immediately issue the eviction order to the sheriff. Parties agree that Mr. Duckworth and Ms. Alexander that if they have not broken the agreement, the court must deny the plaintiff's request to reopen the case and leave the case to be dismissed. No party admits liability or default of admits fault or liability of any kind by entering this agreement. In satisfaction of the court rule, the defendants acknowledge their signatures below and they have prior notice of plaintiff's right to request immediate issuance of the writ of eviction. Further, as uniquely permitted by the court rule in the landlord-tenant proceedings, they agree to waive their 14-day notice period under MCR 2.602 CD. This is the final order is last pending claim between the parties, closes the case in accordance with the stated terms. Signed by McBauer. That's your signature,
I
Ms.
signed,
Bauer.
and I signed this one if you want me to.
Signed by Mr. Duckworth and Ms. Alexander, and Mr. Bradshaw has signed one. Why don't you sign another one and we'll. Mr. Duckworth and Mr. Alexander, did you see and hear everything we just did?
Yes, sir.
Yes, sir.
Let me give you this one back. And you agree with those terms and conditions?
Yes, Your Honor.
Yes, sir.
Meg, that's a very good order. The court form is adequate, but that really spells it out for everybody that's concerned. So thank you.
Thank you,
You
Judge.
guys are good to go. You got till July 20th to vacate, and hopefully you can accomplish that. This matter will be dismissed. You can move on to your next tenancy with your kids. And best of luck. Do you have any questions?
No, sir. Just thank you guys and y'all have a wonderful, blessed day.
Thank you. We're working on it. We'll take all the help I can get. All right. Next in the waiting room is DeAndre Strayer and Emily Horning. We were here last week on this case. The file number is 25939 LT. It's entitled Vista Meadows versus those defendants. We determined last week that the arrearage was $2,000 plus court costs.
If I may.
Yes.
So I was just reviewing the ledger, folks, and it's my understanding that in this particular court, we're only allowed to do $50 per month in late fees. The ledger I'm looking at had the last 2 months at 100. So what I've done in the paperwork I prepared is change that to 50, and therefore the amount due through the month of June would be $1,900 in rent.
Who says I can only charge $50 a month
The judge.
I
in
do.
late fees?
I do.
Okay.
Law is
Okay.
unclear as to whether you can charge a late fee at all. And we've yet to allow $100 late fee. We went from 40 to 50. No one has been able to ever establish a clear right to even charge a late fee. Some courts allow none. I figure that the landlord is entitled to have some compensation for their efforts.
So further in that note, I have prepared the form PC 508 conditional dismissal or a judgment, whatever is preferred, but allowing the defendants until June 30th to pay the amount of $1,900 rent, $266.80 in court costs for a total of $2166.80. I've signed it, but either you folks can agree on the record to let me sign your name or just agree.
All right, well, let me see it.
Yeah.
When we were here last, I think you were working on some sort of plan to pay the rent. You had applied for some assistance. The rent appeared, this guy isn't coming in, the next guy is having trouble. They've reduced it because this court allows a $50 a month late fee rather than 100. We were at 10, they were at 25, then went to 40, then went to 50. Do you agree that you owe that amount of rent?
Yes, Your Honor.
Do you have a plan to pay it?
Yes, Your Honor. We plan to pay it, but also move. We're planning to move, but I fully plan to be paying that off.
Do you have a judgment, John?
I do.
All right, we can go two different ways here. If I did just a traditional judgment, I would find that you had 10 days to move, $1,900 in rent. Boy, this guy, he's tried to join 3 times and he's not getting in here. The next defendant. And you would have until June 30th, the end of the month, to vacate or appeal or pay. Mr. Bradshaw has also prepared a consent order for conditional dismissal that says the case is dismissed without prejudice if you pay that amount on or before June 30th. If you don't, they could reinstate the case. It's not clear to me that you're gonna be able to pay that. This guy.
Of course, the conditional dismissal would be if they move or pay.
All right,
Yeah.
so the benefit of the conditional order of dismissal, it wouldn't go on your credit record. It wouldn't show as a dismissal. So let me read you the terms. The case is dismissed without prejudice, subject to the following conditions. The defendant shall vacate or pay $1,900 in rent, $266.80 in costs, for a total of $2,166.50 by June 30th, or you would be subject to being evicted. As in the last case, the case could be reopened and an immediate order of eviction would enter. So would you rather have the conditional order of dismissal that would place it not on your record? If you pay, I'm sorry, go ahead.
I'm so sorry. Yes, Your Honor, we would take that, please. We're planning, we have a place to be able to move into tomorrow, but we were still planning on paying our behind rent because just in general, we owe that to them. But we will,
All right.
we will take the plea.
All right, Mr. Strayer, you agree as well?
Yes, Your Honor.
All right, I just put agreed on the record. Now, let me tell you something else. When you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay. Yes, Your Honor, thank you.
What town are you moving to?
White Pigeon, Your Honor.
All right, so
We're
you'll
moving in with my mother.
all right. Well, you've got a plan and you agree you owe the rent and you agree to move, and I wish everything worked that smoothly. All right, thank you. I'll send you a copy of this. Stay in contact with your manager. Turn in your keys and give your forwarding address within 4 days of your moving. They can't apply your security deposit to any unpaid rent or other damage.
Thank you,
All
Your
right.
Honor. We appreciate your time.
Okay, well, that's why I'm here.
Let me grab that.
Yeah, I'll give you that one back. All right.
And thank you, sir, for that as well.
Yeah, that's a benefit to you and that is a blessing. The next case is Vista Meadows versus Trevor Dunn. We were here again last week with Casey Strong. We determined rent was, I think, $28.35. The defendant was waiting for his tax return, had some other issues. Mr. Dunn, what's the status here today?
I still don't have my taxes, but I did end up, so I didn't get the job at Wendy's, but I did get an interview at Culver's and got the job. So I start Monday, morning shift at $16 an hour. It should be full time and about 30 to 40 hours.
All right, well, that's a good thing.
And I'm willing to provide pay stubs and all that stuff to help if it helps.
Well, I'm not sure that it will. You're $3,333.40 behind in your rent through June. And you're probably gonna get more behind when we get into July. Mr. Bradshaw, what's your thought here?
So, Your Honor, what I did, first of all, there's an additional $5 because Mr. Dunn presented a check that bounced and that was a $5 charge to us, so I've added that. In addition to that, however, same situation as before, I'm looking at the ledger, there were 2 months where you charge $100 for late fees. I bumped that to $50. Therefore, the current amount due for rent through the month of June is $2,740, not $2,840. There's $198.40 in court costs for a total due through June of $2938.40. Again, I prepared both the conditional dismissal and a judgment, both providing for the same amount of money, both providing that it's due on June 30th.
All right.
Review.
You may have both. Mr. Dunn,
Yes, Your Honor.
We can go one of two ways here. Your landlord can agree to work with you to recover the rent, but they don't have to. If I enter this order today, you would have 10 days from today to vacate, or you would be subject to being evicted. They don't have to enter that order until 56 days from today. So they could actually go all the way into early August to wait for you to pay the rent. But I'm guessing that they won't. Your rent is significantly behind. They have a waiting list of people that would like to move in there. And they'd like you to either pay the rent or move and get somebody in there that can pay the rent. But I say this often, it's a lot easier to keep a good tenant in there than to move one out and move another one in. So I'm not sure what Vista Meadows' view on this is, but at $16 an hour, you're not just gonna suddenly get $4,000, which is essentially what you're gonna be owing through July, and pay all this off at once. So there's also this promise of the alleged tax refund that could redeem this. So we can go two ways here. We can do a conditional order of dismissal as we did in the last case, or I can simply enter a judgment. If I do a conditional order of dismissal, it won't go on your record as an eviction. Either way, you would either pay or move, and they could apply your security deposit toward back rent. Would you rather do a conditional order of dismissal?
I just like to,
They still got a bit. They just don't get an eviction on the record.
I'm sorry, I'm just a little confused on what that means. Does that mean I have to move out?
It means you have to pay your rent or move out by the 30th of June.
Okay.
Now, unless they agree to give you more time,
no,
and they're indicating they don't want to. They either want you to pay the rent or move. So I think I'm just gonna do a traditional
I
judgment.
understand.
All right.
Is there a phone number I could write down to contact them?
Yeah, well, they're right there at your, just go in the office and talk to your manager.
I have spoken with Mr. Dunn several times in the last few months and begged him to pay the rent and given him lots and lots of opportunities. And I've heard income tax. I've heard my father is going to help me pay it. I've heard I'm going to get a job. You know,
It's been 6 months.
we can't pay bills if we don't have rent.
All right, very good. We're just
I
gonna do it.
understand. When I paid the 2,000, that was my whole state tax intern a couple months ago. I'm trying. I just got this job. Staffing agencies don't have nothing. It's
All right,
fast
well, I
food.
understand. It's a tough market out there, but
I'm
they
also
gotta,
fighting for my child and stuff, which baby mama was trying to take from me and stuff.
you mentioned that last week. All right, here's the
And-
deal. Your rent has been reduced by $100 in late fees. You owe $2,740 through June.
All right, and have it by June 30th or
And
be out.
$188, yes, $2,938.40 by June 30th or move. If you pay the rent, great. July's rent is due the next day.
Yes.
So yeah, that's really the whole purpose of this, is for the judge to tell you how much you have to pay and when it's due by. So there's the answer, $2,938. Maybe you can get some help from your folks, or you can get your income tax refund, or you can sell a car or win the lottery. Either way, you gotta pay the rent or move by June 30th. All right,
All
Mr.
right.
Dunn. Good luck, sir.
Yep. Thank you, guys.
This order. We were here last week once again in this file 25941. Ms. Sanchez Wilson is here. Mr. Williamson was not here. He was at work. Is
Yeah,
he not? Hey,
he's at work again.
all right, we learned last week that the rent was 2809 in arrears. 266.80 in court costs for a total of 3,078.80. Have you had the ability to make any payment on this?
I have not received.
Sorry, go ahead.
You go ahead.
Realistically, we don't think that we could catch up with that. So we were gonna see what the next steps would be for moving out.
All right, Mr. Bradshaw, do you have a judgment?
I have a judgment and a conditional dismissal. Same situation, Your Honor. I reduced the amount due by $100 for 2 late payments of $100 each, for 50. So again, the conditional dismissal would allow you to move out or pay, just in case, or I have a judgment as well.
All right, you've heard a little bit this morning as you came in a little bit late, but the conditional order of dismissal would show that the matter was dismissed without putting an eviction on your record. You would have until June 30th to pay or vacate, and if you did not, the case could be reopened and they could ask for a writ of eviction. Would you rather do that?
Yeah.
Yeah.
You said to when?
June 30th.
Okay.
And I'll show a default by Mr. Williamson. What this means is you need to pay that amount by June 30th or move. If you do move, you have to turn in your keys and give your forwarding address in writing within 4 days of your moving. If you don't move, they can ask for an immediate reopening of the case and the entry of a eviction order. Do you understand?
Yeah.
All right, now under the court rule also, you're not represented by an attorney and you just agree to a settlement of the case. You have 3 business days to advise the court that either misunderstood what we were doing or didn't agree with the terms of it. Otherwise, this order would enter as a consent order and you would have to pay the rent or vacate by the end of the month, June 30th. Do you understand?
Yeah.
And you agree to that?
Yeah.
All right, now, if you do move, as I indicated, you need to turn in your keys and give your forwarding address in writing. And they can apply your security deposit to any unpaid rent. They can also perhaps seek any unpaid rent in a damage hearing, but that resolves this matter. So you either need to pay the rent or vacate by the end of the month. Okay?
Okay.
All right. Do you have any questions?
No.
All right. You're good to go. Thank you. This is filed as a demand. No, it's a termination of tenancy. But I thought I had a question about this. The lease is from July 5th of 24 to June 30th of 26. So it's a 2-year lease. It's filed as a termination of tenancy, but it looks like the only reason for termination of tenancy is non-payment of rent.
Yes, Your Honor, that'd be my understanding. I know that there was a domestic issue with one of the individuals, Mr. Baker. I believe there was a restraining order put in place, so he's not to be back at the property. The landlords then worked out a deal for past due rent with Miss Baker, and no payments have been made, and they haven't been able to communicate with her since, and that was months ago.
Are they there?
Miss Baker is. Mr. Baker is not, but he's on the lease. So for the sake of being thorough, we wanted to include him here. He was served.
Well, they're both personally served. It's a termination of tenancy for not paying rent, but they have a lease. So normally they would have an opportunity to pay the rent or vacate. However, this was filed just as a termination, no just cause, just they didn't pay the rent. So if it was a situation where it was a month to month and the notices were given, but this is a default situation. He was personally served. Neither party is here, so they know of the action. They have a defense that they aren't here to raise. And as a practical matter, how much is the rent arrearage?
At this point, Your Honor, it's 10,300.
Yes. All right. I'm going to default a termination of tenancy. Let's see if I have a judgment in here. I don't believe I do. Could you send me one?
I will do so right now, Your Honor.
The date for the writ, it works out well, as the 10th day from today, which is June 30th. I can't exactly envision which house this is. It's right at the south end of Three Rivers. I drive past it all the time, but I can't picture it. At any rate, they're substantially behind, $10,000 behind in rent. He's not allowed to be there anyway. They were both personally served. I'm gonna allow the writ of termination of tenancy 10 days from today. If you email that to me this morning, I'll sign it.
We'll do so right now, Your Honor.
All right, very good, thank you.
Thank you.
The next matter is entitled Brittany J. Busher versus Amy Dutka. The file number is 251021 LT. This is filed as a demand for non-payment of rent. Miss Busher, this doesn't look like a very good deal. She moved in January, paid a couple months, and then stopped paying. She isn't here now, but she was not personally served. She was served by substituted service. What else can you tell me about this?
So, the trust was broken from the very beginning, because even the first month's rent was late. And I have not had any contact with her since March 20th.
It's okay, girl. Okay.
So now I haven't received payment for April, May, or June. And I've also paid for the utilities, February, March, April, and May. And that was her responsibility.
Well, how much is due? Let's talk about rent first.
So the total amount for rent now is $4,200. The late fees are now
Wait a minute.
$225.
How much are the utilities?
Utilities are $221.71.
All right. And costs?
So altogether, we're at $4,464.
Wait.
Yeah.
The court costs are the filing fee of $130 and the process serving fee of only $26.
Oh, yes.
26. So the costs are $156. All right, let me add that up, see if I come to the same number you do. 4200 plus 221.71 plus 156 is 4,577.71. That's the number I get through June. Is that what you get?
I did not add the court costs or the process serving into my total amount, so we did vary just a little bit.
All right, well, let's take a look at our proof of service. Is she still there?
I believe so. Her vehicle has been there. The
How did you come to
gentleman.
get in the landlord business?
So, my circumstances changed a little bit at the beginning of the year. And so I thought I would rent out my house for a year and see what happens. But yeah, it's my first experience and I've learned a lot.
It's not a very good one. Let's see
No.
here. She was served on a co-defendant, Kyle Weirgal. So we don't have personal service. You're aware there's another person there?
I was not aware until I saw him outside one time when I drove by, and then through this personal service situation.
Well, she was not personally served, so I can't do a default is the point of that. So I have to adjourn this 1 week to June 27th. How about if we continue this to 8:45 on June 27th?
I'm available. I will be there.
It will be by Zoom just like this. And then at that time, they'll have 10 days to vacate or be subject to being evicted. And that will add also July's rent into the equation. So we'll have to change the numbers, but you're gonna be $5,500 or more that you're gonna have a hard time collecting. But I can't do a default judgment unless I have a personal service or a second mailing. I don't. So yeah, this probably seemed like it was gonna work, but not so good. All right, I'll see you next Friday morning at 8:45, okay?
Great, thank you so much.
Good to go, thank you. I'm still trying to figure out which case you're here on. Who is your landlord?
It's River, hold on 1 second. River Side Estates. And it's
All right, what's
25.
the?
The
go
case
ahead.
number is 25-1059-LT.
All right, so you're with Stacy Perk and
No, Angel Florence.
Perk and Jeffrey Ellis?
Yes, sir.
All right, how are you connected to that?
Well, she was my girlfriend for, I don't know. We've been together almost 8-9 years. So common law, we're basically married, but she's with another man now. So
All right, well, that matter isn't set till.
we're roommates is all. She was homeless. I was homeless.
So, all right, do you
and
still live there?
No, I was, my understanding was the manager, Jason, I can't think of his name now. Damn it. But anyways, I was
All right, well,
understanding
anyway,
that.
just sit down and
Yeah.
stay quiet, and we'll try to figure this out.
Okay. Thank you.
All right. Boyer and Allen Freshour. And good morning. And Jeff, I'm going to advise all of you as your rights in a landlord-tenant proceeding. As a defendant in a landlord-tenant proceeding, these are both non-payment of rent cases. You have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And attorney Meg Bauer is here from Legal Aid on the feed here this morning. You have a right to have trial by a jury or by the court. If you do wish to have a jury trial, you have to tell the court, me, at this first appearance, or file a written demand within 5 days and be prepared to pay the jury demand fee unless the judge waives the fee. Mr. Ware, would you just sit still? You seem to be working on another project, or just sit quiet and listen to what I'm saying here.
I'm listening.
All right, you have a right to demand a jury trial. You have to pay a $50 fee unless the judge waives it. You have a right to have the case heard here in St. Joseph County where the property is located. You do have the right to ask for potential financial assistance. You may be able to get assistance from the Michigan Department of Health and Human Services, Housing Assessment and Resource Agency, help for homeless veterans, if you're a veteran and eligible for those services. You do not need a judgment against you to get that help from the places listed above. The problem is most of these places don't have enough resources to go around. Copy of the summons and complaint from your case is sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested in that process, the court can help set it up. You may be able to reach an agreement with the landlord that means the case would get dismissed. We did several of these this morning with the filing of what's called a conditional order of dismissal. We would assist you in that, or generally the attorney would prepare it. Mr. Burns is here on behalf of Riverside Estates. And that's a little mobile home park tucked away between 131 and Lutz Road. Courtney Swartz and Robert Jones are here. Can you hear me?
Yes.
All right, Mr. Burns, could you unmute your mic?
Yes, Your Honor.
I have some disclosures to make in this case. I know Courtney Swartz. I've known her since she was a baby, essentially. And she called me several months ago and said that she was struggling and there were issues with her tenancy. And so I referred her to an agency that I think did give her some funding. Then she called and said this was coming. And I said, well, Courtney, I can't talk to you about a case that's going to be pending in my court. And she said, okay. And I said, well, I'll see you when it gets here. Mr. Burns, in light of those discussions, do you have any concerns about me handling this case?
Not if Your Honor believes he can be impartial and carry out the job of a judge in the normal course of business, given his relationship. And I understand the concern, but if the court believes it can do its job in the normal course of business, given the relationship, I think we wouldn't have any objection, and I'd leave it to the court to make the decision.
All right, thank you. I do not feel the need to recuse myself, but if either party wants me to, I would. Ms. Swartz, do you have any problem with me handling this matter?
No, Your Honor.
All right. There's a number of these, and in each case, it looks like the rent is gotten pretty significant. It also appears to me, Mr. Brown, this is a circumstance of lot and trailer. They're renting both the lot and the trailer.
That is my understanding. Yes, Your Honor. It's home and lot rent. Yes.
All right. What is the current arrearage in the Swartz and Jones case?
Your Honor, there's a rent to retain of $7,921.61, costs in the total of $223.75 for a total due and owing of $8,145.36. And just for the court's records, all of these were filed as possession only. None of them have money judgments attached.
All right, Mr. Jones and Ms. Swartz, you owe a lot of rent and you have to pay that or be prepared to move.
Yeah.
And what's your position?
Well, when we first moved in here, we did get some help. And it all got messed up from the very beginning. We still owed like $3,500 when we first moved in. And if we would have known that, we would have started paying sooner than we were supposed to, I guess, because they paid like the first 3 months rent. But after that, we were still behind $3,500. And we just been trying to pay as much as we can. I was not working at the time. It was just Rob. I am working now. And I just gave them $6,000 at tax time. And it went like $800 for a pet fee that we had already paid.
And I've been trying to talk to Jason about it, and I talked to Brian, and I don't know. We're just trying to catch up to finally be able to stay ahead.
Well, you've got a substantial arrearage and you're gonna be more behind in July. But the law requires that I adjourn this matter for 7 days. So that takes us to June 27th. And I got too much stuff in there too. I'd like to continue this to June 27th at 10:30.
Okay.
All right.
And I am still trying to get help from that, from one of the places that I reached out to also.
Now, let me tell you something else. I referred you to the one agency and I thought they had actually given you some funding, but
No,
you owe
we had the
you owe a lot of back rent. And let's say that one of the agencies gives you $5,000. You would still owe the remainder, which would be over $3,000. And the only thing that cures this is paying the entire amount of the rent. Partial payment will not prevent the writ of eviction. My suggestion is that you should start to look for someplace else to move to. You're so far behind on the rent, I don't see you having the ability to catch this up. But we'll address this. Now, if they get what they ask for, you would get 10 days from June 27th to move or be subject to being evicted. And that would be July 7th. Meaning if you don't pay this rent by July 7th, the sheriff could come put you out on the street on July 8th.
Okay.
But we're gonna address this further. Now, Meg Bauer is here from Legal Aid. I don't know if there's a legal defense or it's just a matter of being way behind in the rent.
I'm happy to consult with them, Judge.
All right.
And your honor, I'd ask that the defendants reach out to me and see if we can coordinate something with my client in terms of seeing if there's other options available. And I'm always available too if they need to talk.
All right. His name isn't on the pleadings. His name is Michael Burns, but his number is on the Levine Swistack law firm, 248-851-8000. They can do some sort of agreement, perhaps, of a conditional dismissal or some sort of agreement as to how to get caught up on the rent.
Okay.
His name is Michael Burns.
Tell him that.
I mean, I've been working for Jergens. I just got my, I just did my yearly review. I just got another raise. I've been trying to pay, and then I've been paying on the van. I've just been trying to make it, and I just got behind.
Yes, I understand it, but you're way behind. And so, all right, now they're willing to talk to you, so I suggest that you do that.
Did you have?
Can you? Pleadings. I've got the number. I'll read it to you again. Okay. 248-851-8000, and the attorney's name is Michael Burns.
Okay.
He's in beautiful Farmington Hills. All right. I don't know, Meg, that they need a legal consult. Maybe they can just, do you wish to talk to legal aid or simply see if you can work something out with your landlord?
See if we can work something out first.
All right. Very good. Next week.
It should, they said.
The problem is I don't want to put it right now because the same tenant has the same issue. The next tenant has the same issue. So, all right. So again, she's here to consult with if you wish to, but I'm not going to force you to. You can simply talk to your landlord. She'll also be here next Monday if we need assistance at that point.
Okay.
Okay.
All right. All right. I'll release you.
Thank you.
The parties are here. Megan Bauer is also present from legal aid. This is also appears to be lot and trailer for the whole unit. And that would be about $1,000 a month, $955. Mr. Burns, what the current arrearage?
Current arrearage, Your Honor, is rent to retain of $7,937.26. We have costs in the total of $222.70 for a total of $8,159.96.
All right, your case is similar to Mr. Jones and Ms. Swartz. A lot do. Now, somebody sent me a bunch of pictures, and I'm not sure whether they're from the defendants or from the plaintiff.
They're from us.
All right, and you show me that the water doesn't work. There's all kinds of issues with the property.
Yes.
And that you would ask for repairs and they have not completed them.
Exactly.
And I believe I have those photos as well, Your Honor.
Right. Meg, this is why I wanted you to stick around for this one. This one has a little more to it. This is a small little park tucked away in the woods. Nobody knows it's there. It's old. The units are old, and I haven't seen much of them, frankly. So they are arguing that there should be abatement or reduction of the rent for these other issues. Let me ask this, Mr. Burns, when was rent last paid?
On my ledger, Your Honor, I have rent hasn't been paid at all this year. Let me see if I can find the ledger going back into the previous year. The only thing I have, Your Honor, is beginning at the new year, there was a balance of, they actually had a credit of $284.08. But as of the first of this year, no rent has been paid on the account.
All right. Now, there's a way to do this. If you're going to withhold your rent, you have to pay it into escrow, and nobody ever does it right. Very rarely do people ever do it right. So you're alleging that you shouldn't have to pay rent because of the deficiencies in the tenancy. Is that correct?
Yes.
Yes.
Actually, Your Honor.
Did you tell your landlord you weren't going to pay the rent anymore?
We have.
So what happened back in November is the propane ran out.
November, we decided not to actually stop paying rent in November, and then come the end of January, our propane ran out. And
right now, I saw that in the pleadings, but who's responsible for paying for the propane?
Okay, we are, but the propane is in the
Landlord's name.
Yeah, so we're not allowed to have it get filled or
order it or anything like that. So when I reached out to Brian, I could never get a hold of him. I worked through Jason. I also called the gas company myself to have them come out. I was going to pay them then and there. Brian ended up calling again, saying that I did not go further.
We spoke on the phone yesterday. I have that conditional dismissal.
I was wondering if it's possible to speak to.
Okay. Saying that we cannot go further with the gas getting filled because I had back rent. I told him that I was glad that he finally reached out to me, because ever since I moved in there in August, I had been trying to reach out to him about the problems we were having. Never once did he contact me. So it was never my intention to not pay the rent. I just withheld it until he got a hold of me. So come time for me to get the gas filled, I mean, we went 5 days without having any heat. The whole place is ran on gas, and I have 3 kids. So I paid the back rent and everything and got up to date a little bit further ahead. And he still never came and fixed the sewage. He still never.
When it was out heat for 5 days, we finally get a.
All right, well, let me ask a question. Why didn't you just move out? This seems like such a deplorable place to be.
I've been looking as well, and I mean, it's very hard. I've got 3 kids that are in Constantine school. I wasn't trying to just rip them out of school. I mean, I work here in town, you know, so it's just been very upsetting and very hard.
I don't think, when we moved in there, we never got a checklist. There was no, the furnace didn't work. There was no
All
fire.
right. There's all kinds of deficiencies here.
Oh, yeah.
So they're asking you to pay the rent or move. And you don't wish to pay the rent and you don't wish to move. So we've got to figure something out. You're living in this place with improper sewage and you've had no heat and there are issues regarding that. I'm gonna order that you pay the rent to me.
Okay.
I'm gonna do an escrow order. We're gonna set this for a hearing on a day where we have more time than next week. There's more to this case than a regular tenancy case. Megan Bauer is here from Legal Aid, and they are the specialist in landlord-tenant law, particularly in representing defendants. You may have some defenses to their request to have you pay the rent. I keep hearing about Brian and Jason. I'm not sure who they are. They must be the owners of this property, and there are these kinds of issues. Does your sewage work now?
It keeps backing up, but they keep, Jason.
Jason is the maintenance
is
man.
the maintenance man. He keeps opening up the sewer and dumping it on the ground. It's pretty nasty underneath our trailer and in the yard.
This is also a health department issue.
Yeah.
Right?
So I went to the health department and I had said something. She told me that, you know, if it didn't get resolved, to come in again. I never went back because Jason did tear up the yard and put a new pipe in it and everything. But I mean, I still have to call down like every other 2 weeks to drain it.
This had happened with a park a number of years ago. Water was filthy. Water from.
There's at least 4.
All right, well, Mr. Ware, Mr. Ware.
I'm sorry,
Please
yes.
be quiet. It's like you're sitting in the courtroom and you can't have a private discussion with someone else. We're in the middle of a court proceeding. I ask you to sit.
I didn't know you could hear me.
Yes, so please be quiet. I called the health department myself. This was 15 years ago. Sewage was discharged onto the ground. They put in a drain field that was not even on their property. And the health department was reluctant to simply condemn it and make everybody homeless. But I fear there are some significant sanitation issues out here. So there may be more to this. So Ms. Bauer, well, one of the problems, Mr. Burns, is July is coming.
Yes, Your Honor.
And we've got vacation and conferences and 4th of July and trying to figure out a place to put.
Because of the nature of the case, Your Honor, if the court is inclined to adjourn it until after the holiday, I don't think we would object. And I think that may give us some more time to address some of these issues. And if I may, just in response, I know there are ongoing issues, but based on the documents, it looks like my client has been cooperative at the least in addressing these issues. Specifically the propane, it looks like the order was placed for the propane and it was delivered within a day or two. And there have been communications and there have been resolutions to some of these issues, though I know some of them are ongoing. But I have no problem taking an adjournment till after the holiday so we can work out what we need to between my client, myself, and the defendants.
Your Honor, may I say something about the propane issue?
Yes.
There was 5 days with no answer from Brian, and then he calls Amanda, and the first thing he says, are you ready to pay me my money? 5 days we went without heat and no answer from him. And then he threatens to shut off our lights because we didn't pay him back rent.
All right. My suggestion again is that you move.
Yeah.
But we're going to fight about this. you're gonna pay the rent to me, which is money you could better use to find first month's rent and to move somewhere else. But you're going to pay escrow to the court, and the court's gonna hold on to it. So let's assume there are all these deficiencies. That doesn't necessarily mean that your rent is zero. There may be a reduction or called abatement of the rent because of these other issues. But right now you're paying no rent. And so each month we're just going to be farther in the hole. And I'm trying to figure out where to put this. And I think we're going to have the same problem in the next case. Perk and Ellis, although they're not here.
I am.
Yes.
I mean, I could have showed up in the courthouse. That would have been better for me.
All right. Well, you're fine. You're fine. Someone is there as Riverside Estates. I can't see them or hear them. I'm not sure who's there.
Your Honor, I believe that is representative from the community, the Brian. Mr. Newsom.
All right. I'm not sure what to do with this. Either just set it for 1 week and then figure out what we're going to do, which is what I think I will do. I will continue this to June 27th, 2025 at 10:40. Now, we're going to talk about this further next week. And at that point, I can set the matter for a trial. And I'm going to order that you pay escrow to me, which would be $995 for June and $995 for July. If you don't pay the escrow, they win. I'm going to order what they ask for. And then you have to pay that amount or move. And my thought is that you could use that money better somewhere else. You're fighting to keep this tenancy that you don't really want. Then let's say I cut the rent in half. You're still going to owe $5,000, even if I cut it by 50%, which you can't pay. And then you would have 10 days to move after that. So there are a lot going on here. Megan Bauer is here from Legal Aid, and you could benefit from a consultation with a lawyer that does this sort of thing. So for now, I'm going to continue this matter till next Friday, June 27th at 10:40. Mr. Burns is going to be here anyway on the other case.
And Your Honor, I'm sorry.
Go ahead.
Is the court entering an escrow order now, or is that going to be entered at the next hearing?
I expect to enter it at the next hearing unless we work something else out. We'll still be in the month of June.
Yes, Your Honor.
Mr. Burns, have you ever been there?
I have not, Your Honor. I am familiar with manufactured housing, though, having worked in communities myself, and we do a lot of representation for communities. So I am familiar with sewage issues as they arise, and I am familiar with what causes them and the responsibilities therein outside of my job as a lawyer for the community.
Well, you seem, I've never dealt with you before. Your firm has a fine reputation in doing landlord-tenant work. But I would suggest you look at it. It's not an order, but I think it might be enlightening to actually see what this place looks like. At any rate, we'll continue it for a week And I'm gonna put the parties in a breakout room with Meg Bauer and they can discuss this. You heard what my opinion is, but I'm only the judge and my opinion doesn't carry any weight. My court order does. And at some point, they're gonna get what they're asking for. You're gonna have to pay some money or move. So when you see this, click the button that says join and you'll be in a private space with Attorney Bauer. All right, so you're Jeffrey Ellis.
Yes, sir.
All right, so you're there at this lot 14?
No, I haven't lived there for quite some time, Your Honor. It's uninhabitable. Has been since December of 2024. And work recommendations were applied several weeks. And
All right, well,
nothing
just a
was
minute.
ever-
Is
Okay.
Angel Perk still there?
No, she has another apartment. I'm kind of in between homelessness and living with my parents again.
All right, do you have any objection to them simply taking possession of this trailer back?
I do is for a few reasons. Number one, I still have property there.
All right.
I was issued a no trespassing order from showing up at a campsite with a bonfire uninvited, and the police came and issued me no trespassing order. So I'm not allowed at 15717 Withers Road, which has my belongings. Well, the only thing I have left is in this shed, and my jacket was on the couch. I thought I had my wallet in it, and my wallet ended up found by the Sturgis Police Department by the library. So I don't know what the hell's going on. The night the escort from the police came, I asked Jason to lock the place up, and he didn't even shut the door, lock it, or nothing. So who knows what went on there? And Jason Feck,
When
the
was
manager.
when was this bonfire?
It was a few weeks back. I don't know, a month maybe or so. I woke up on the couch. I was feeling fine. Coherent. Not. I had been drinking. I bought 240-ounce beers, and I drank maybe one and a half by midnight that night. But for some reason, I woke up and I saw the bonfire down at Bob's place, and Bob's wife, who I'd never met before, told me I wasn't Bob's friend. And they
All right. I guess you're telling me more than I need to know. It sounds like this place is uninhabitable anyway, and nobody's in there.
Yeah,
But
well,
you need permission. You have my permission to return to the property and receive any
Okay, well,
retrieve any of your property.
thank you, sir. I have I have the heating element that would go to the water heater that went out in December. That was the first work order that should have been taken care of. I purchased it
All right,
myself.
well, let's see if we can accomplish this. You go get all your stuff out of there, and we'll address this further next Friday.
It's just a box of brand new tennis shoes and some odd and end tools and some wood. Nothing serious.
6/27/25 at 10:45.
But
Go get your stuff out of there, and then
Okay.
next week we can discuss just releasing the property.
Okay, well, there is I have an issue with the billing of I'm still getting billed for rent, and there is no running water. There's no
All right.
electricity.
We're just gonna get you to relinquish the property, and then we'll fight about money damages later. But yeah,
Okay.
this is uninhabitable.
Yeah, there's 3 different kinds of molds growing: white, green, and black.
All right.
All over. I mean, seriously, all over.
All right, go get your stuff. We'll discuss it next Friday morning at 10:45, and then we'll just give them possession of the premises. And if they're gonna fight about back rent, we can do that later.
Okay, thank you, sir.
All right, I'll see you next Friday
Great.
at 10:45.
All right, you have a nice weekend. Thank you.
All right, thank you.
And I believe that's all for me, Your Honor. So I appreciate the court's time today. Have a good weekend.
We got a couple wrinkles there. That one, it sounds like they've totally vacated and she's gonna be subject to default. So we'll just ask for immediate possession next week.
Sounds good, Your Honor. Thank you.
All right, thank you. We were here last week, June 13th with Casey Strong. Meg Bauer was here. You indicated you were looking for a place to move to. And apparently they've worked out an agreement in this matter. Mr. Bradshaw, what's the status here?
So, Your Honor, first of all, I reviewed our file and all the notes from Ms. Strong regarding legal aid's involvement in this case. I do not see an appearance. So yesterday afternoon, I did reach out to Ms. Malone and offer her the conditional dismissal, which I believe you have in front of you, which allows this case to be dismissed and stay dismissed as long as Ms. Malone vacates the premises by July 31st, 2025. If she does that, there will not be a judgment. I told her that that was the best we could do. And that was our offer. She indicated to me on the phone anyway that she was in favor of that. The only alternative, I assume, would be to move forward on and request a judgment in 10 days. I don't believe there's any issue because I believe at the last hearing, Ms. Malone stated that she was in fact smoking in the unit. And I think if testimony were provided today by Ms. Tyler, that would also indicate that there was smoking in the unit. She had personal knowledge and personal information to that effect. So long story short, sorry, conditional dismissal is what we're presenting. And it's my understanding Ms. Malone agrees to that, vacate by the end. We did not ask for a money judgment.
All right, Ms. Malone, did you agree that you would vacate by the end of July?
Yes, sir. I did on the phone. I didn't get a chance to talk to my legal aid, a lawyer. I was trying to see if I could do that today, but if not, I guess I just have to.
Well, I'm gonna make her available. I'm gonna have you wait, and Mr. Bradshaw will have him wait a second also.
Sure.
So stick with me.
Yep.
Ms. Tyler, same for you. All right, now, every Friday and Monday, when we have landlord-tenant cases, right in the middle of them, we have several general civil motions. So I have to change my way of thinking. So let's see who all we've got here. Mr. Conley, good morning to you, sir.
Good morning, Your Honor.
I've got a couple people that are here barely. All right, I've got Motorola G. Who am I speaking with? Your microphone is on mute.
Angel Perk.
Oh, Angel Perk. Angel, you're late for your hearing.
I was sitting in the waiting room. I do apologize. I did drive over to Jeffrey's.
Yeah, Jeffrey was here. He says he's vacated, you vacated. The place is not habitable. I gave him permission to go get anything you wish to get out of there. And I continued the matter until next Friday at 10:45.
Okay, I appreciate that, sir.
If you got anything you wish to get out of there, go get it out of there, and we will address this next Friday at 10:45, okay?
Okay, thank you. Thank you so much. All right, bye-bye.
All right.
How do I exit?
Yes, we call it the.
All right, Miss Perk,
down
you, there, she's gone. All right, now I've got somebody who's a telephone number. Who's here just by telephone?
Your Honor, that would be me, Cheryl Miller.
All right. You were there before and then you disappeared.
Yeah.
All right, Mr. Dylan Ringel, you are there, but I can't hear you or see you.
Yeah, I'm here. I just unmuted. I have the video showing, but for some reason it's not showing me.
All right, just stay where you are for a moment.
Okay.
Mr. Bears, you're here on two cases. Which two are you on?
Here on Ringel and also here on Omni versus Brian Walters.
All right. We're gonna do, and Mr. Polaris, you're here on Bank of America.
That's correct. Cheryl Miller, the defendant.
All right. We will first deal with Mr. Conley's case. Meg, we're gonna take a default here, and then we're gonna need your help with Evelyn Malone, and then we'll free John up. All right, this matter is file 25354 GC. It's entitled Three Rivers Health versus Susan Beers. Mr. Robert is here for Three Rivers Health. He's represented them for a long time. The defendant is not here.
I'm right here.
Oh, she is here. Susan Beers, have a seat over here if you would. I'm sorry, I was looking for you on the screen and you were live in person.
Yeah, I was out there waiting for the Zoom and she told me just to come inside, so.
Yes, it's how we used to do court. All right, this is a motion by the defendant to set aside a default. It isn't really, but that's what I interpreted it as. This is a claim for $3,999.40 plus cost for a total of $4,235.80. Mr. Conley is representing Three Rivers Hospital in that regard. The defendant was personally served with that lawsuit on March 13th of 2025. She did not answer or file any response to the lawsuit, so a default judgment entered on April 17th, signed by Judge Pattison while I was sitting on Siesta Key Beach. He rarely signs any of my civil orders, but I'm gone for a week. Sometimes he will sign some defaults. So he signed the default order on April 17th. The defendant filed a letter dated April 28th. So it's within 21 days of the entry of the order. It isn't certainly in the format of a motion to set aside a default, but I'll read it. My name is Susan Beers, and I'm writing to you because this hospital bill has already been paid a few years ago when I worked at Decorators in White Pigeon. They are still taking my taxes for it. I've even been over to Three Rivers Hospital and talked to the billing manager, and she said this should have never happened because I'm on Medicaid. I've not been to the hospital since they sued me March 14th of 2025. So I set it for a hearing I mean, it would have been a lot easier if she showed up when she was supposed to, but she didn't. So she didn't file an answer, default entered, and then she wrote that letter. So I set it for hearing. In order to set aside a default, you have to show two things. You have to show a legitimate reason for not appearing for the hearing and a meritorious defense. I'm not sure why you didn't answer the pleadings. And your contention is that the bill has already been paid?
Yes. I've even been to decorators to try to get a paper showing that it was paid, but they told me that they only keep records of it for a few years. So I called their
All right, first
main
of all-
office and they told me the same thing. They don't keep copies of it for so long. And it's only been like 3.5 years, maybe 4. It was before my father passed.
Decorators was your employer who carried your insurance?
Yes.
Do you know who your insurance was through?
I didn't have, well, I had insurance through them and I also had my Medicaid. And like I said, I had been to Three Rivers Hospital and just discussed all of this with the billing manager, and she looked up everything and she said that I had Medicaid at the time, that this should have never ever happened. She said she don't know why it did.
All right. Mr. Conley, we deal with these from time to time. First of all, what's your reason for not filing an answer to the lawsuit?
Well, I was in the process of dealing with my mom's passing and cleaning out her house. And in the time I had just got done moving to the address that I was served at. And then shortly after that, I was in a car accident in Sturgis and it totaled my car, so I didn't have transportation to get anywhere.
All right, Mr. Conley, she has some unsupported allegation that the bill was already paid and then some unnamed person at the hospital told her it never should have been filed in the first place, when the hospital is the ones that ask you to file it. It's hard to even get a handle on something like this. What's your response?
Well, Your Honor, with all due respect, Ms. Beers is wrong. This has not been paid. I have an open judgment against her in your court, case number 22-791GC with a $5,447 balance. You signed a consent judgment for $100 a month. That's what I'm getting tax karma on. She made 2 payments and stopped. She claimed the same thing on this case, and I had a file on her before that. So this is now the 3rd file. They billed her insurance, which was Aetna at the time that she provided the hospital on these 2 accounts, and they didn't pay anything. So she needs to get a hold of her. She's claiming Medicaid. She needs to call her Medicaid rep, which is so far old now that I don't think they'll even touch it. But she has never done anything to get a hold of her Medicaid rep, to discuss Medicaid with the hospital, provide the hospital with the Medicaid information. So we just keep going round robin. And I think she has so many accounts for all these years that it happens quite a bit where people get confused, don't understand all these accounts. But yeah, this is wide open and has been billed.
No, when I made that agreement for $100 a week, they had garnished my wages and it was all paid for when I worked at Decorators. Because she said when the bill was paid, they would instantly stop the payments on it. And she told me it was completely
Who is
paid off.
she? You're just somebody, some nameless person somewhere. Who told you this?
It was in the office for the bill, when that did the paychecks and stuff at Decorators.
Oh, Decorators. Do you have
Yeah.
anything in writing from anybody?
No, I don't. That's why I said, that's why I was trying to get a copy of it.
Your Honor, she
because-
might be right because this is my 3rd case against her. The first case was from 2017, and that thing has been closed for a while now. It's purged now, but I might have hit her with a wage garnishment on those accounts. Then I got another file, which is open, case number 22-791 for 7 more accounts. And now I got this account for 2 more accounts. She didn't answer. She's bringing up the same defense, and she never does anything to take care of it. And here we sit. I don't even know if she's collectible, to be honest, because right now I don't even think she's working. So
Probably not. As a practical matter, it's going to be difficult like this. I don't
and I haven't
find
had a chance to talk to her about it. I've been calling her and she doesn't answer or return my call, so I'm not sure what to do. But I already filed a wage guard on this one at Universal Forest Products, and then I got this motion to set aside.
All right, I don't find legitimate reason for not answering once you get, and I don't find a meritorious defense. A bunch of hearsay, somebody told me something that somebody told me something. There are other cases there. The motion is denied. What I would suggest you do is call Mr. Conley and try to discuss all of these open cases. There was a repayment agreement that failed, so now they're garnishing your wages and nobody likes that. But I don't find that there's a just cause to set this default judgment aside. And we're all stuck with it.
Well, I don't understand it because I have not been to the hospital until the 14th of March when I had to go in and have an upper GI.
Well, again, that's all in the lawsuit. But what I would suggest that you do is contact Mr. Conley and discuss this. If you go out to the counter, I'll give you a copy of this order, but I've denied your letter request to set aside the default. Even though I'm supposed to construe per pleadings broadly.
I've even got a paper at the house showing that they've been taking my taxes for all this since the first time.
Yes.
Even though it's all been paid.
Well, I don't believe it has been paid.
It was paid. I had the papers and then I moved.
All right. Well, you don't have anything to establish that. So they contend it's owed.
These are different accounts, Your Honor. I think she's just.
Yes, I understand.
Okay.
All right. You go out to the counter and get a copy of the order. I would suggest that you contact Mr. Conley and discuss it further, but I have not granted your order. All right. You're free to go. Thank you.
Thank you, Judge.
All right. We're in kind of the same circumstance. Let me take care of this hanging landlord-tenant case. We had to wait for our legal aid attorney to come back, and then we'll return to our other matters. Ms. Bauer, Ms. Malone is here. They have given her until July 31st to vacate. They indicated Casey Strong and Mr. Bradshaw that they had attempted to contact you on this case, but there was never an appearance from legal aid, and it wasn't clear whether you were involved in the case or not. So Ms. Malone had agreed to vacate by July 31st. They won't pursue any money damages. That gives her actually an additional 40 days to vacate, but she wanted to talk to you further before she completed that. So are you agreeable if I put her in a breakout room with you? And
Absolutely, Judge. I did have communication with attorneys Strong and Bradshaw about this case on behalf of Ms. Malone, but we obviously had not filed an appearance.
all right, well, Ms. Malone, click the button that says join the breakout room. Can you see that? You see the mouse there?
No, I don't know how to work this. I have to
All
have
right, could you help her, please?
I don't want to break nothing.
We need for you.
My staff is very helpful. All right, Elaine, Meg will be here working on other matters. Okay. Some of these are easier than others. Omni Credit Union versus Brian Walters. Eduardo Pilares is here on behalf of the plaintiff. This is plaintiff's motion for summary disposition.
Good morning, Your Honor. Jeffrey Beers, P 41693.
Mr. Beers, you're on that one. I had it backwards.
That's okay. P 41693 on behalf of plaintiff Omni Community Credit Union.
This is a substantial amount for district court standards. $17,045.23 plus costs. Defendant filed a generic answer using the state court form. That gets you past the default, but it does not get you past a motion for summary disposition. In addition, the defendant isn't here. Is anyone here on behalf of Brian Walters? The motion is appropriate on its merits. So I'm not going to show as a default. I'm going to show grant of summary disposition. In the amount of $17,369.33, which includes the damages, attorney fees of $75, and court costs of $249.10. I'm going to sign that order. All right, showed as summary disposition in that amount. All right, Mr. Bear, as long as we got you on the hot seat, let's take up your other matter.
Thank you, Your Honor. On Omni Credit Union, I just want to let the court know that we did prepare a consent judgment on that. We emailed it to the defendant's debt settlement company on June 12th, and they never signed it or sent it back. And we did call several times and could not get through, and they just hung up on us after 4 times. So we're proceeding with our motion for summary this morning, and we stand by it, and thank you for entering the order.
Thank you. All right. All right, let's take your other matter. Dylan Ringel.
Yes, sir.
All right. This is Capital One versus Dylan Ringel. This, and I apologize to everybody, this was the day the courthouse was closed because the power went out. And we're all standing here looking at each other with no electricity. It was set for May 16th, and it had to be bumped to today. So people they couldn't figure out what was going on. There was a storm the night before and the power went out. So Jeffrey Beers is here on behalf of Capital One. So this is an objection to garnishment. This judgment entered in the amount of $10,000, $669 plus costs. And the defendant filed an objection to garnishment. And frankly, Mr. Ringel, I don't understand it. You filed the objection to garnishment on the state form in the proper manner and paid the fee, but I'm not sure what your objection is.
Yeah, so I actually did a debt resolution program. And when I signed up for that, the representative at the company had said that they were going to communicate with the debtor or the creditor, sorry, because I had 3 loans, this one being the largest one, that I wanted to have all into one payment. So basically I started paying towards the debt resolution program to lower the payment because I had a job change, which lowered my income. But they never communicated with Capital One, so then I got a notice of wage garnishment. So since then, I've canceled that. So, I mean, I'm fine with just paying them at this point.
All right, so what you'd like to do is, rather than have a garnishment, enter in some sort of repayment agreement?
Yeah, I mean, that ideally, that's what I would like to do. Yes.
Mr. Barris, what's your take on this?
Your Honor, a motion for installment payments is not before the court today. I'm scrolling through the notes to see if we've had any communication with Beyond Finance. Only a call from Mr. Ringel on April 24th saying that he canceled Beyond Finance. So we would need some more, we need some financial information from him before we could agree to a monthly payment given the high balance.
All right, here's what I recommend, Mr. Ringel. I'm gonna deny your motion to set aside the default. You did it on the state form, which I appreciate. The objections are invalid and they shall release the garnishment funds to the plaintiff. What I would suggest you do is today or Monday, come in and file what's called a request for installment payments.
Oh, okay.
And that would set aside the garnishment and set up a payment plan, but they're unwilling to do it at this point because they need more information.
Okay.
It's called a request for installment payments.
Okay. Will do.
All right, the sooner the better for you. In the meantime, the garnishment stays in place.
Okay. Thank you.
All right, you have any questions?
Nope.
All right, you're good to go.
Thank you.
Do you need me to submit an order, Your Honor?
No, you guys did, or my clerk prepared one, so I've got one in here. I find the objections are invalid. The garnishee shall release funds to the plaintiff attorney.
Thank you.
All right. All right, sorry for the disjointed nature of the proceedings this morning, but we're doing the best we can. Thanks.
Thank you. Have a good weekend.
Yeah, I'm working on it. If I get through all this, I probably might. All right, Mr. Polaris, let's take up your matter. Cheryl Miller, can you hear me? Cheryl Miller, can you hear me?
Yes, Your Honor, I'm here. No.
Miss Miller, we're in
Your Honor,
court.
can you hear me?
Yes.
Okay. Thank you.
I didn't really want to do this by telephone only, but we had to just do the best we could.
Okay.
This is entitled Bank of America versus Cheryl A. Miller. This is an old case. Bank of America has been attempting to collect on this debt for 24 years. File number 112086. Defendant was subject to garnishment. There was a garnishee disclosure, and defendant again just filed a state form objection to garnishment, said the funds are exempt without saying anything more. So your claim is that whatever was garnished was exempt. They filed a brief in response to that. And
I'm sorry, Your Honor. Who filed a brief about that?
They
I
did.
haven't received anything. I guess is what I'm trying to say. I haven't received anything.
Let me look. Maybe I got my facts straight. Yeah, dated April 24th, 2025. Plaintiff's response to defendant's objection to bank garnishment. Filed April 24th of 2025. Sent to the River Road address. Anyway, you then submitted some more information. Further complicate things. You don't even live in St. Joe County. This address is in Cass County, and it never should have even been here in the first place, but we're here now. Some white pigeon addresses are in Cass County. Yes?
Can I get the key to unlock the doors?
Yes.
It's ever so slightly locked.
Well, why did you break it?
That's a question. Also, I was told he wants to add something to his order for his next case.
All right, very good. Okay, so we had a long hearing on May 12th. Mr. Perlaris was here. We started to make a record. We were going through it, and then you showed up late, and I continued the order until today. There was a question whether the funds were commingled or not. So you submitted some other stuff, which we received. The date stamp on that is May 1st. So, Mr. Polaris, what's your take on this now? Screen seems to be frozen. Mr. Polaris, what's your take on this?
For the record, Eduardo Polaris, P63559 on behalf of plaintiff. Your Honor, this, as you pointed out, this ended with the defendant admitting that she had transferred the alleged Social Security funds to a different account. The issue was whether or not those funds had lost their protected exempt status once she started moving them around between accounts. Defendant was to present additional documentation to be able to show that we could trace those funds back. I understand the court received something. We did not. The defendant did not serve us with whatever she sent to the court. So I'm at a bit of a disadvantage here because I have no idea what evidence is being presented. Obviously, the law is pretty clear on this. If the funds have been commingled, there is no way to separate Social Security from non-Social Security funds. Exempt status is lost. If it's just transferred to another account, the automatic exemption is lost. However, it's up to defendant to prove that those funds come from Social Security only. I don't know if the information for the court shows that because I don't have it.
Oh, wonderful. We probably should have forwarded to you ourselves. Exhibit 1, healthcare questionnaire, healthcare determination notice, 5th, 3rd. All right. Well, I wish I'd have left this case in Cass County back in 2011 because that's where the defendant lives. And then she wrote a letter. I'm not clear as to whether plaintiff owns or has been assigned the rights to present this claim against me. I'm a resident of Cass County and resolve at South River Road, White Pigeon. I have not resided or owned property in St. Joseph County for at least 40 years. And I believe that Cass County is the proper venue for this complaint, which is probably correct, except that was correct in 2011. It's a little late to change venue now. The documents that you sent, Miss Miller.
Yes, sir.
I'm not sure that, what do you claim that they do?
Well, actually, Honor, I have a 5 to 10 minute presentation which covers exhibits, testimony, and to present legal arguments for the record, if I may do that.
I'm not gonna let you do that by telephone. You didn't want to come in here. You didn't want to come in with video, and you've got a presentation that you wish to make by telephone.
Yes, sir.
And you're claiming you never got their pleadings, response to your objection.
No, sir. I do not believe I did. I did send the exhibits to the attorney. I'm sorry, I did send those.
All right. So what you filed on May 1st, you sent to the law firm?
Yes, sir.
Judge, I'm in our paperless system right now. We show nothing received on this, so I'm not sure what happened.
Yes, I did send exhibits and the memorandum of law, I believe I have in front of me.
Certainly, we would like an opportunity to respond. However, a third hearing on this seems a little wasteful at this point.
I agree, but she claims she hasn't seen your pleadings and you haven't seen her pleadings. So I'm going to reset this for a 1-hour hearing. Live. I'm going to let you do this by telephone or without having more information. You filed these pleadings, which frankly, I don't understand them, but you're prepared to make a presentation. But Mr. Polaris hasn't had a chance to review them. When you send them to, you're supposed to send a proof of service indicating that they've been sent, but I will send your pleadings to plaintiff.
Okay. Thank you.
And I will send plaintiff's pleadings to you.
Thank you.
I'll reset this for a 1-hour hearing live, date to be determined. I'm sorry, Mr. Polaris.
We won't be able to appear via Zoom, Your Honor?
I have to be in for a penny, in for a pound, so I can't make her appear. Ms. Miller, can you appear by Zoom?
I have tried before. That's why I was late the last time, but I tried. Short answer, it doesn't.
Plaintiff may appear by Zoom. They've been trying to collect on this debt for 24 years, $2,000.96. And you've been ducking the collection for a long time. And they finally got a garnishment that stuck. And your claim is somehow that it's exempt, but I can't quite figure out your pleadings. You claim you didn't get the stuff they sent to you. You claim you sent stuff to them that they didn't get. I don't know whether I believe either of those or not, but we're going to make sure everybody's got everything. I don't have a date right now, and I will set a date, and we'll give everybody notice. All right. So we'll address this further at another time. Mr. Polaris, you will be able to appear by Zoom.
Thank you, Your Honor. We'll see you at that time. I'll await the notice to appear.
All right. All right, so we got sideways and behind on some of our other cases, but let's see if we can resolve Evelyn Malone. Then we'll do the Chevernoy case, and we'll be ready for our damage hearing.
May I grab that
Excuse
order
me,
from you, Your
Araya.
Honor?
Ms. Malone, would you have a seat right over here?
May I grab that order from you? I'm gonna make one more notation.
Yes.
Your Honor,
Yes.
excuse me, this is Cheryl Miller.
Yes.
Are we done with,
Yeah, we're done. I'll let you go.
and we,
Thank you.
Well, I didn't like to leave that case unresolved, but it's messy, it's old, and I just kicked the can down the road. We're returning to the matter of Three Rivers LP versus Evelyn Malone. The file number is 25934LT. Evelyn Malone is here in the courtroom. John Bradshaw is here, and Megan Bauer is connected by Zoom from Kalamazoo. We had discussed a conditional order of dismissal where the defendant would agree to vacate by July 31st. She wanted to discuss that with Ms. Bauer, and so we made that opportunity available. Mr. Bradshaw, what's the status now?
So the status, Your Honor, is essentially the same as far as the date. I'm going to present a conditional dismissal. It's Form 508 that states that the defendant shall vacate the unit on or before 7/31/2025. There's no money due. Under further conditions paragraph, I put defendant shall vacate the unit and turn in keys by 7/31/2025, period. Plaintiff agrees to only give a neutral reference to potential landlords. So I've added that part. Box 4B is check stating that if Ms. Malone doesn't vacate by the 31st, the next day, I could potentially ask for a judgment and an order of eviction, which is what we're trying to avoid. I've signed it. Do you want me to present it to her to sign?
Yes, please.
Sign it on the second page. Yeah.
Ms. Bauer, have you discussed those terms with the defendant?
I have, Your Honor.
And she's agreeable to that?
I think that that she is making a smart decision. And she is agreeable, yeah.
All right. Ms. Malone, do you agree you're going to move by the end of July?
Yes, sir.
Now, you just entered into a consent judgment here in the courtroom. And when we do that, the judgment cannot be entered or enforced until 3 regular court business days have elapsed.
And just to be clear, it's a conditional dismissal, same effect.
But it's conditional dismissal, but I'm going to give her the consent anyway.
So I'll make sure that I pay my rent and utility for the month of July, so I don't get behind on anything.
And Judge, I did indicate to Attorney Bradshaw, he could put my information in the caption. I don't know if he got the message.
I didn't do that. I wasn't sure. I don't have it. And so
Yeah,
I'll just put Ms. Bauer.
okay,
also.
there you go.
Okay. She's
Hey, what's your P number?
84816.
All right, Ms. Malone, you've got the rest of June and the rest of July to vacate. And that's better. If they got what they asked for, you would have had 10 days from today to move. And as it is now, you get 40. Hopefully you can find another place to go to and they'll give you a neutral reference. And they're not ordering any money judgment today. I appreciate the fact you're going to pay July's rent. That will be helpful. What I want you to do now is go out to the counter and they'll give you a copy of this order. Do you have any questions?
No,
All right, you're free to go.
thank you.
Thank you, Your Honor. Thanks, Meg.
Thank you, John.
All right, we have one more landlord-tenant matter. This it was set for 10:30. We're about 15 minutes behind, but that is entitled Lamp and Key. Oops, wait a minute.
Oh.
I gave you a lamp and key.
Oh.
Properties versus Trevor Chevernoy. Diana Lamont, the property manager, is here, and Howard Bush, counsel for Lamp and Key, is present. The file number, if I didn't say it, is 24864LT. Mr. Chevernoy is not present. We were here last time on June 13th, indicated the defendant got VA assistance. They were trying to find other housing for him. Mr. Bush, what's the status here today?
I do not believe that he has paid anything further. I would ask my client to confirm that.
That is correct, Your Honor.
All right, well, he was served by attachment, so we weren't able to do the default last week, but we can do it now.
And we have heard nothing further from him.
All right, I think we determined that rent was $800 plus 25 late. Is that what we decided, and $260 in costs?
That sounds correct. There's $55.40 on service fees, the 75, and then the filing fee. So that sounds correct. I didn't add them up.
130 plus 55.40 plus 75 is 260.40 plus 825 is 1,085.40. Miss Lamont, is he still there?
He is, Your Honor.
Do you think that he intends to pay or move?
I believe he wants to move.
All right. Well, he has until June 30th to appeal, and he has until June 30th to pay it. No money judgment is entered at this time, and a default has entered. Partial payment will not prevent the writ of eviction. Is Stoney somebody working with him on this?
Stoney and I have been in contact on this client, yes.
All right. All right, $1,085.40 due by the 30th of June, or he's subject to being evicted. All right, that finishes our herky-jerky morning. We do have a damage hearing set for 11 minutes from now. We're going to take an adjournment. Thank you. I've signed your order. You guys are good to go.
Thank you.
Okay.